Mrs. Manning, go ahead. Okay. Okay, you go ahead. Oh, okay.
I'll do it on my way out.
Okay. Okay, are there any matters we need to get on the record on behalf of the state?
Yes, Your Honor. I believe the state submitted to the court and parties a motion last night regarding some issues that state would like to discuss or at least be heard regarding defense expert witnesses and the order in which they plan to call their witnesses. Other than that, Your Honor, the state has no further witnesses for its case in chief. I believe we are likely to have a rebuttal witness, assuming the defense puts on a case. Pending admittance of the state's exhibits, the state would rest.
Okay, thank you. Okay. Did defense get a copy?
Your Honor, I was aware about 7:30 last night, I think, and that's when Ms. Hamlin sent it to the court or maybe to the bailiff. Yeah, we printed one out this morning, Your Honor.
Okay. Then any argument on behalf of the state first?
Yes, Your Honor. With respect to, we kind of wrapped some of the things that we had talked about earlier into motion that laid out some case law and cited the proper rule. I guess the first thing I will address is the duplication of experts. We feel that it's the same standard, whether the experts who are operating in their, they're going to give an opinion as to whether the defendant was operating within nationally recognized police practices. We've been told earlier that these two experts come to their conclusions in different ways. I've read both of the reports numerous times, and I'm still left curious about how they're coming to their conclusions in different ways. The reports are laid out very similarly. You have Mr. Scanlon, who talks about the facts. He breaks down the facts in question, and then just gives his opinion that these facts and the defendant was operating within generally recognized police practices. Their other expert, Kevin Davis, he lays out the same facts, breaks them down, and then maybe cites a quote from a source, and then says the same thing, that these actions by the defendant are within generally recognized police procedures. So again, the state feels that that is duplicative testimony, and at that point in time, after the first expert for the defense testifies, it would make the second expert's testimony not relevant. That's with respect to that, Your Honor. The other issue is with respect to order of the witnesses. We had discussed I believe on Friday, that the defense may call their experts prior to the defendant taking the stand. I've pointed out a rule as well as case law that clearly indicates an expert witness cannot get in otherwise evidence that has not yet been admitted. And here in this case, this testimony and statements of the defendant have not yet been admitted into evidence. If they're going to use that information and come up with their analysis and give their conclusions of whether conduct fell within generally recognized police practices, that is fine, but I believe it would strictly prohibit the admittance or the use or the production of his testimony and his statements to the jury before those underlying statements have been in themselves been admitted into evidence. I believe the court referenced, possible med-mal cases where, you have experts talking about things that are otherwise hearsay, and I don't obviously contest that, but I would argue and hypothesize that those documents had already been admitted into evidence. There's probably stipulations on both sides that the documents have been admitted into evidence, and therefore that expert can then talk about the specific contents of those documents, even outside of giving their overall opinion. Here, it's different. Here, the defendant's statement is not in evidence, so for an expert to get up there and say, I read in Officer Coy's statement X, Y, and Z. He said X, Y, and Z. I interpreted that to mean this. Based on general police practices, that's appropriate or not appropriate. I think that is outside of the rule. I think that's outside of what the case law has clearly indicated is permissible. The case law that we have researched has found that this is it's outside of the discretion. The expert is only able to testify about things, perceptions gained from direct personal examination of the defendant or facts and evidence admitted at the hearing. Here, we don't have that. Thank you, Your Honor. I have an additional item.
Okay.
Would you like for me to wait and address these issues separately, or?
No, go ahead and make your argument.
Thank you. With respect to the measurements, again, talking about the experts, we had a discussion before. The court had excluded certain photographs that the defense was attempting to maybe use with their expert. The state also feels that, especially since those pictures were prohibited from becoming used in this trial, we also request and make a motion in limine that the experts aren't allowed to do those things on the stand. I believe there was measurements taken through the witness, Asia Chung, who was a crime scene search unit. The state would object to any of those types of activities happening with an expert on the stand. Again, that is outside the scope of the report. The case law and the rules clearly state that experts are only allowed to testify to things that are contained in the expert report. None of the experts talk about measurements. They just make a general statement that the defendant's interpretation of the keys could be interpreted to be a revolver. That's it. There were no measurements taken or anything like that. Again, the state would have done and could have done things differently had that information been contained in the report and there were going to be measurements taken and comparisons taken from that standpoint. So the state would object to an expert witness on the stand making those sorts of measurements as well. Thank you.
All right, thank you. Any response?
Your Honor, very briefly, with regards to the duplicate, you've already ruled on this. I'm not sure why we're arguing this again. The court's already ruled on it and indicated that we can, and if it becomes duplicative, you will steer us off of those issues. So, I mean, the court's made a ruling. Same with regards to the third thing, Your Honor. You said the exhibits don't come back. However, any demonstrations that an expert wants to do, you're going to allow them to do. I mean, it's demonstrative. Experts are always asked hypotheticals. Experts are always asked about demonstrations. And, if we want to do that on the stand, you've already indicated, Your Honor, on a previous ruling that we're allowed to do that. With regards to the order, again, Your Honor, The experts are sent a long time ago, statement by my client, written statement by my client, and all the evidence. They have to review the packet of discovery that the government has. That packet of discovery is sent to the experts. They base their reports on that. So they're basing their reports on information that my client gave and things of that nature. They could put that in the first case. They can call their expert in their case in chief. They chose not to, Your Honor. So I guess I'm not sure where this is coming from now. We have a burden in this case to try to restrict our order of presentation of material is not genuine with regards to, we can't restrict their order and things of that nature. If they wanted to call their expert in the case in chief, they could, Your Honor. That's happened in several cases in the police shootings that we had. It happened in front of Judge Young with Andrew Mitchell, Your Honor. The government put their expert on their case in chief. They get to choose because they have a burden as well. They get to choose whether they put that on in their case in chief or a rebuttal, Your Honor, depending on the burden that they so to speak. So, you know, you gave us guidance on Friday, Your Honor, and, you know, for scheduling purposes and things of that nature, and it was off the record, and I understand why the need to address on the record for the protection of the record, but we would ask that you follow the advice that you gave us on Friday, Your Honor.
Okay. In response?
Yes, Your Honor. I argued this on Friday without having the rule in front of me. Now I have the rule in front of me. And now I think it's important that we follow the rules that have been laid out. And Rule 703 clearly states, yes, the state could have done a lot of things, but we chose not to put his statement into evidence for strategic reasons. And yes, experts rely on this information. I'm not saying that it should be excluded entirely. I'm just saying that if they're planning to ask the witness, their expert witness, and have that verbalized to the jury, those things need to be admitted into evidence prior to them doing it. I'm just asking the court to follow the rule. That's all I'm doing. Thank you.
Your Honor,
You may.
I can't admit my client's statement, Your Honor. I can't admit his written statement. I can't admit his taped interview. I'm precluded from doing that by the rules of evidence. So it's a situation, Your Honor, in which cross-examination, if our client says something different than his statements, they're allowed to cross-examine on him. They can't cross-examine an expert on our client's testimony in court versus what he said in his statement versus what he said in his written statement. They're not allowed to do that because we have a separation of witnesses in the state's cases, and experts in state cases can't sit in during the testimony. In federal court, they can. That's why they're allowed to do that. So again, he indicates about admission. I can't admit my client's statement in our case in chief. I can't admit his tape recording. So the experts have nothing to do with his testimony if he testifies and so chooses to testify, Your Honor. So basically what Mr. Pearson's saying is if our client doesn't testify, then no experts can testify. And that's just not the case in these types of cases, Your Honor.
Okay, thank you. Okay, as to the duplicate experts, I think when we had discussion before, one of the reasons that the court ultimately overruled the state's motion, I mean, the state has had the expert reports for, I don't know, years, I guess. And we're getting ready to start the trial, and it's at that point in time that the state then makes a motion to exclude one of the experts. Now, the court did indicate if both of the experts are essentially testifying as to the same thing, the court will accept any objections at that particular time and may exclude certain testimony from one of the experts, depending on the duplicate nature of that. But the court has already ruled that the defense can present the two experts. As to Evidence Rule 703, I mean, 703 indicates that an expert can base their opinion on facts or data. Hold on. Personal knowledge of the facts or data underlying his or her opinion. That knowledge is a permissible predicate for his or her testimony. It does also indicate that an expert could base their opinion upon the testimony that is presented. But in this case, and again, the example, says, for example, an attending a physician who treated an injured plaintiff would have firsthand knowledge of the facts which could permissibly support expert opinion testimony as to the permanence of the plaintiff's disability. In this case, the expert is aware of the supporting data by reason of her or her firsthand experience. Again, they're basing their testimony on documents that were received, or I guess treatment of the plaintiff that occurred prior to the trial. You wouldn't need the plaintiff to testify as to what happened to them for the expert then to come in and opine. Again, the expert's testimony, and I'm assuming both experts, well, both sides' experts are testifying based upon information that was provided to them prior to court. I think it would be, well, it would be left to further objections if the defendant testified and then the expert offered an opinion different than what was presented earlier based upon testimony in court that is contrary to what the experts reviewed. Obviously, if the defendant does testify contrary to what's in the report, then that's open for cross-examination and potentially inconsistent statements which potentially could impact the weight that the trier of facts give to the testimony of the expert witnesses. So the court does not believe that it's necessary for the defendant to testify first in order for the experts to offer opinions. Obviously, they're going to need to get into the record what they're basing the information upon which they're basing their opinions upon. Well, all the experts will need to do that. And that's the information that was provided prior to trial. Okay. As to the expert getting on the witness stand and presenting measurements, again, the court does not have any issue with the experts doing so. Now, the experts, to my understanding, did not offer any opinions in their report as to what those measurements would mean. They cannot come into court today or tomorrow and then say, based upon the length of the keys, we have an opinion. The court would consider that impermissible. Obviously, either side can argue what that means, and it would be up to the trier of fact to decide whether or not they find any significance whatsoever to the length of the keys, to what the defendant alleged that he believed that he saw. So having the expert do the measurements, again, court has no issue with that. Experts can't offer any opinion as to what those measurements may mean because no opinions were offered before. And part of the reason that the court excluded the defense from using the photographs was because of the fact that the court found those to be staged and the photographs would be difficult for the state to be able to cross. But with the witness attempting to make the measurements on the stand, the witness would be available for cross-examination. So the motion is denied. All right, anything else for the record on behalf of the state?
Not on the record, Your Honor.
Okay, on behalf of the defendant?
No,
Okay. All right, excuse us a moment. Counsel, please approach off the record. Thank you, ladies and gentlemen. You may be seated. All right. Which exhibits is the state moving for admission?
Thank you, Your Honor. First, the state has the A series of photographs, A1 through A88.
No objection, Your Honor.
All right. A1 through A88 will be admitted without objection.
Next, we have the B series of photographs, B as in boy, B1 through B44. Those are the inside photographs of the residents at 1062 Oberlin.
Any objection?
No, Your Honor.
All right. So the B1 through B44. Okay, all right. Yeah, B1 through B44 will be admitted without objection.
Next, we have the C series of photographs. Those are the cruiser, the SUV, and the clothing. Those are C1 through C66.
No objection, Your Honor.
All right, C1 through C66 will be admitted without objection.
Next is the D series of photographs, the officers and the firearms. That's D1 through D17.
No objection, Your
D1
Honor.
through D17 will be admitted without objection.
Next is E, the autopsy report. Includes several pages.
No objection.
Okay. Not the autopsy photos, but the report.
Correct.
All right, and what is that marked?
That's marked as E.
Okay, all right. All right, so E is admitted without objection.
We had also had double E, the supplemental autopsy report. I don't think that we need to move to admit that. That was just the doctor saying he agreed with.
Okay, so double E is not being offered.
Correct.
Okay,
Then we have the photos, the autopsy photos, which are E1 through E8.
No objection, Your Honor.
all right. E1 through E8 will be admitted without objection.
And for the record, I did notify defense counsel, E1, we had the numbers backwards. We needed to flip the photograph, so it was not displayed with the numbers in the right order. We flipped the photograph, fixed it, saved it, and so it'll go back to the jury correctly.
Okay, all right.
We are skipping the letter F exhibits. We did not present that exhibit. The next one we would move to admit is State's Exhibit G, which is the 911 call.
No objection, Your Honor.
Right. G will be admitted without objection.
And for the record, that was stopped at the time that the witness was about to give his phone number. So we redacted that, so the phone number is not on there. But everything prior to that is
Okay.
there. Next is H, the body-worn camera of Officer Coy that was redacted and played in court.
All right,
Provided that that same thing goes back to the jury.
okay. Yeah, I guess sort of redacted G, redacted H will be admitted without objection.
Next is State's Exhibit I, which was the Leica scan map of the scene that was used with Agent Chung.
No objection, Your Honor.
I admit it without objection.
State's Exhibit J, which was Officer Coy's handgun, the magazine, and the rounds that were in the box there.
No objection, Your Honor.
J will be admitted without objection.
And Judge, just so I understand, I know the exhibits won't go back for a bit, but before I forget, what is the court's policy as far as handguns and sending it back to the jury? Do you keep them? Yes. Okay.
My bailiff will retain it, and if they wish to see it, she'll take it back for them to see it.
Thank you. State's Exhibit K, which was Andre Hill's clothing.
No objection, Your Honor.
All right. K will be admitted without objection.
State's Exhibit L, which was the money, the debit card, and the phone holder.
No objection, Your Honor.
L will be admitted without objection.
State's Exhibit M, the cigarette pack.
No objection.
Okay, M will be admitted without objection.
State's Exhibit N, which was the projectile recovered from Mr. Hill from the 11th intercostal space.
No objection, Your Honor.
N will be admitted without objection.
N1, which is the projectile recovered from Mr. Hill's buttock.
No objection, Your Honor.
N1 will be admitted without objection.
N2 is the projectile that was recovered from the ground or on the floor of the garage.
No objection, Your Honor.
N2 will be admitted without objection.
State's Exhibit O is 4 shell casings.
No objection, Your Honor.
O will be admitted without objection.
For the record, they'll all be clipped together in their individual packages, but all of them collectively, all 4 are the letter O. State's Exhibit P are the keys.
No objection, Your Honor.
P will be admitted without objection.
State's Exhibit Q, the handcuffs and the glove.
No objection.
Q will be admitted without objection.
State's Exhibit R, the cell phone and the T-Mobile case recovered from the SUV.
No objection.
R will be admitted without objection.
State's Exhibit S, the phone recovered from the driveway.
No objection, Your Honor.
S will be admitted without objection.
State's Exhibit T, which was Andre Hill's footwear, shoes, socks.
No objection, Your Honor.
T will be admitted without objection.
We do not have a State's Exhibit U that we are using, so we'll skip that. We next have State's Exhibit V as in Victor, which is the body camera footage from Amy Detweiler's body cam. It's the redacted version that was played in court.
With the same redaction going back, Your Honor. No objection.
All right. Redacted V will be admitted without objection.
Next, we have, excuse me, W, which is the ballistics report, and then W1 is the stipulation that goes along with it.
The stipulations we reviewed, Your Honor, they're fine.
Okay. So W and W1 will be admitted without objection.
Then we skip several letters for exhibits we ended up not using. Next would be State's Exhibit CC, double C, which is stipulation number 2, the identity of the victim, which we read into the record on Friday.
So stipulated, Your Honor.
All right. Double C will be admitted without objection.
We had a State's DD, double D, but it was just a summary that was used to refresh Agent Chung's memory. So we are not asking to admit that.
All right. So not offering DD. Okay.
And I believe that is it. And just for the record, we have an exhibit notebook with all these items in them printed out, with the exception of there is a USB that contains the audio and video for State's Exhibits G, H, and V, which are the 911 call and the 2 redacted body cams.
All right. Very good. At the appropriate time, the court will remind counsel to make sure that the correct documents are going back to the jurors. But we'll do that at the close of all the evidence.
Thank you.
All right. All right. Anything else on behalf of the state at this time?
No, Your Honor.
Okay. Anything on behalf of the defendant at this time?
Yes, Your Honor. At this point in time, Your Honor, we would ask the court to issue a Rule 29 dismissal, Your Honor. We understand the burden is the facts viewed most favorably in light of the state at this point in time and whether or not, and that's the burden where reasonable minds could not agree. However, in this situation, Your Honor, the record is completely devoid of any testimony regarding recklessness. There has not been presented one scintilla of evidence that our client was reckless. They chose not to call their expert in their case in chief, Your Honor. Recklessness, as the court is aware, is a heedless indifference to a known risk. The state's case in chief, Officer Detweiler went through what risks are, went through how they're trained, went through the responses, action versus reaction. I think it was Officer Branford as well discussed those issues, and you do not have to wait until you're fired upon. So the case in chief of the state, Your Honor, is completely devoid, like I said, of any evidence of recklessness. I don't see how 12 reasonable jurors could disagree about that. With regards to any redirect of Amy Detweiler or anything of that nature, Your Honor, there was nothing about, rushed, things of that nature, something that would lead to a reckless or disregarding a known risk. You heard the exact opposite in the state's case in chief, Your Honor, that's what they were investigating, potential risks. So there was not a heedless indifference to disregard or not examine a risk. So here, Your Honor, the recklessness standard under recklessness homicide, again, the video was played, I understand that, and shots were fired and someone died as a result of that. But that's the only thing in the record with regards to anything concerning that. And that video in and of itself has no bearing on recklessness, Your Honor. That's where the experts come in, so to speak. With regards to the same with the serious physical injury, Your Honor, the felonious assault, now you're at a knowingly standard. And again there, Your Honor, Officer Detweiler and Officer Branford both said they were not trained to shoot to injure. They were not trained to shoot to cause a felonious assault. They were not trained to shoot to kill somebody. They're trained to stop the threat. Sometimes a threat, Your Honor, is stopped and the person it lives. Sometimes the bullets miss, or depending on the type of lethal force. Both of them testified about, again, police concepts with regards to their training and the response. So in this situation, Your Honor, again, we don't believe the record is anything that would 12 reasonable jurors would disagree with regards to the knowingly aspect of causing serious physical injury to someone on a felonious assault with a deadly weapon, Your Honor, because the evidence in the record so far indicates that did not happen. The same, Your Honor, the proximate result, you must have a felonious assault underneath there. And again, Your Honor, that's the state's case in chief. They chose not to address those issues, and we would ask for a Rule 29 dismissal on all three counts, Your Honor.
Thank you. Any response?
Thank you, Your Honor. I'll start with the felonious assault and the knowingly aspect, proximate result. Clearly, the actions of Officer Coy were knowingly as it relates to a felonious assault. The definition of knowingly is when a person is aware that a person's conduct will probably cause a certain result, will probably be of a certain nature. Person has knowledge of circumstances when the person is aware that they probably exist. Here, it's evident that firing his firearm, as he is trained to do, to stop a threat, it's most certainly knowing that he is likely to cause serious physical harm. It's clear that there was serious physical harm to Mr. Hill, given that he passed away as a result of these injuries. This needs to be viewed in the light most favorable to the state. This is a question for the jury to determine, and given all of the facts and circumstances here, the firing of his weapon 4 times at Mr. Hill constitutes knowingly. That plays into the murder charge as it relates to it being the result of the proximate result of a felonious assault. With respect to the recklessly aspect of reckless homicide, as the court knows, A person acts recklessly with heedless indifference to the consequences. The person disregards a substantial and unjustifiable risk that the person's conduct is likely to cause a certain result or be of a certain nature. A person is reckless with respect to circumstances when, with heedless indifference to the consequences, the person disregards a substantial and unjustifiable risk that such circumstances are likely to exist. The state submits that it has proven recklessness in this case as well, based on all of the conduct of Mr. Coy. The jurors have seen the video there. They've heard the testimony of Officer Detweiler. They've heard the steps that were taken or not taken as it relates to the testimony of Amy Detweiler, what she knew of Mr. Coy's conduct, what they did do, what they didn't do, given Mr. Coy's approach to the situation, given the conduct that he had as far as having his firearm, having the information that he did obtain with respect to the license plate involving the vehicle there. All of those things indicate that his conduct in this case was reckless. This is a situation that the jurors have heard this information. It should be up to the jurors to make a determination as to whether or not they believe that his conduct was reckless. And construing that in a light most favorable to the state submits that it has met its burden with respect to Rule 29. Thank you.
Thank you. Any response?
Briefly, Your Honor, the question that begs the answer is what risk was disregarded? There's no testimony of a risk that was disregarded here. I mean, that's in the definition of the recklessness. Officer Detweiler indicated and corroborates that he wasn't. I mean, they haven't put anything reckless because based on what her limited thing in there and what she observed, she had her gun drawn, Your Honor, and low and ready. So again, the government has put forth no risk that was disregarded by my client's actions. And so we would ask, in fact, that you Rule 29, the reckless homicide, Your Honor, there at this point in time, they had strategic reasons for calling who they called. They have not put forth any evidence that 12 jurors could reasonably disagree about with regards to a known risk, that they've given no risk.
Okay, thank you.
May I, Your Honor?
Yes.
The state just wants to point out that his approach, his shooting of Mr. Hill as he's coming out of a garage, as he's complying with the request to come out without giving him any orders in terms of put your hands up, things of that nature, that in itself constitutes recklessness. Thank you.
Anything else on behalf of the defendant?
No, Your Honor.
Okay. As to counts 1 and 2, the court does find that viewing the evidence in light most favorable to the state at the time that the motion is made, that reasonable minds can reach different conclusions as to the proof beyond a reasonable doubt. There is sufficient evidence in the record at this time for the jurors to consider the actions of the defendant. The predicate for the murder, the felonious assault, did knowingly cause serious physical harm. Officer Coy intended to fire his weapon, did so knowingly, and in doing so did cause physical harm to Andre Hill. Having met the predicate in count 2, the court finds that there is sufficient evidence in counts 1 and 2 for the jurors, for the trier of facts, to consider the evidence in both of those offenses. And as a matter of law, the court does not find that Rule 29 would apply. As to the reckless homicide, I think both counsel have correctly indicated that the instructions that the court will provide to the jurors, a person acts recklessly when with heedless indifference to the consequences, the person disregards a substantial and unjustifiable risk that the person's conduct is likely to cause. A certain result is likely to be of a certain nature. Person is reckless with respect to circumstances when with heedless indifference to the consequences, the person disregards a substantial and unjustifiable risk that such circumstances are likely to exist. And then substantial risk, strong possibility as contrasted with a remote. The court does find that there is evidence in the record that the jurors could find that the actions of the defendant were reckless in this matter, in the facts and circumstances as presented in the state's case in chief. Obviously, there's testimony from Officer Detweiler that she reacted and performed in a manner different and contrary to that of the defendant in this case. The jurors can consider that in determining whether the actions of the defendant were indeed reckless based upon the information that they have before them in the record. Therefore, as a matter of law, the court will deny the motion as to Criminal Rule 29 as to what we have as count 3, reckless homicide. Okay. All right, is there anything else on behalf of the defendant at this time? All right, as the court has indicated to counsel, when we bring the jurors in, the court will give the state an opportunity to rest in front of the jurors. After the state has rested, I will ask if there's anything on behalf of the defendant. At that time, you may call your first witness.
May I use a biology break real quick?
You may. All right, let's take 5. Yes.
When it's red, you know it's good, but blue is on. I muted it and turned the video off, because if I don't, it's always on him when he moves.
I know it. Got other things on my mind. What can I say?
I did both.
I put this all on.
Trying to take lunch, I'm gonna have Andy run down, but that's maybe 12:31.
No, probably 12.
Oh. We're just trying to get 1 or 2 done, probably.
No, as much as we can.
Yeah.
You mean over the course of the day or the morning?
Huh? Oh, today. I mean, morning.
Yeah, I mean, if we can get both of them in the morning. I mean, the only bad part about all of this,
12:31-ish.
because Not anticipating the state resting today.
Yeah.
Oh.
Is it happening again? I think, well, they know, especially when they come in, don't, because they were going straight downstairs.
Okay.
Well, nothing really, is it?
And then here's the CV and just the report. Like I said, I'm not moving it into evidence or anything like that, just for him to refer to. I have it marked, Renee, as 11 and 12.
11 is the CD?
Yes.
And 12 is the, okay.
Yep.
I'll be crossing him.
Oh, I'm sorry. So I, yeah, okay.
Yeah, oh, I will.
I'm going out. Have you crossed him before?
I have.
Was it in Pike County? What'd you do down there? A corrections officer? In front of deer?
Oh, I think so.
Oh, no, I got there at 9:30 and I was 7 by 3.
My bad, I thought you said you were there. Still 9:30.
Sorry, I wouldn't be able to hold it till 11 or 11:30. Oh, man. How did that? Oh, because it takes a while for the building to get all the systems, yeah. And the glass, you know what I mean?
The volume on this camera is still on, FYI.
Oh,
Just got a text.
not live.
Yeah, but don't say anything. Thank you. If you turn that off for me, everybody. Yeah, because it's in there.
You may be seated, ladies and gentlemen. All right, good morning, everyone.
Good morning.
Welcome back to courtroom 4B. At this time, we'll proceed forward on behalf of the state.
Thank you, Your Honor. This time, the state rests.
All right, thank you. Okay, anything on behalf of the defendant?
Your Honor, we would like to put forth a case, and we will call our first witness, Kevin Davis.
Okay. Morning. Please raise your right hand. Do you swear or affirm that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, as you shall answer unto God under the pains and penalties of perjury?
I do.
You may be seated.
Thank you, Your Honor.
All right. It's important that you speak into the mic so that the ladies and gentlemen of the jury can hear you. It's also important that you respond verbally. Sometimes it's difficult to interpret.
Understood, thank you.
For the record, if you would, please state your name, spelling your last.
Kevin, R as in Robert, Davis, Davis.
You may inquire.
Thank you, Your Honor. Good morning, Mr. Davis.
Good morning, Counselor.
Can you tell the jury a little bit about yourself?
Well, I'm a retired law enforcement officer from 1982 till 1990. I was a deputy sheriff with the Summit County Sheriff's Department. County seat is Akron. From 1990 until I retired in 2021, I was an officer with the City of Akron Police Department. I worked a variety of assignments in the Sheriff's Department, corrections, uniform patrol. And then when I transferred over to the Akron Police Department, I worked uniform patrol, transferred into street narcotics, and then began working for the Training Bureau, where I was a full-time trainer for about 18 years. Collateral with that, I was a member of the Akron Police Department SWAT team, where I was a team leader and lead instructor for the Akron Police Department SWAT team.
You said you're retired. How do you like being retired?
I'm busier now than I was when I was working.
What do you do for a living now?
I'm a consultant and a trainer and expert witness. I run my own business.
You talked about the various assignments and positions you've held throughout your career. How long have you been in law enforcement?
Well, as a police officer or deputy sheriff, 39 years. And then since I retired in 2021, I've continued to work in the field, so somewhere around 45 years.
Thank you. In order to become a law enforcement officer, Mr. Davis, did you go through the Ohio Peace Officer Training Academy?
I did twice, actually. Once when before I became a deputy sheriff, I went through the Portage County Sheriff's Academy, and then when I was hired in Akron, I had to go through another basic academy.
Now, you mentioned that you're a trainer. Are you certified to teach at OPATA?
I was for a number of years. I no longer teach in basic academies or for agencies, so I've let my certification expire, but I was a certified instructor for 25 or more years.
And I apologize, I use the acronym OPATA, but what does that stand for the ladies and gentlemen of the jury?
That's the branch of the State of Ohio's Attorney General's Office, Ohio Peace Officers Training Academy.
What areas specifically were you certified to teach in with respect to OPATA?
My primary focus was on suspect control and tactics. When I left the Akron Police Department Training Bureau, I was the lead firearms instructor. I taught use of force, tactical operations, traffic stops, a variety of different subject areas.
Have you presented on law enforcement topics?
I have at international training conferences, an organization that's no longer around called American Society of Law Enforcement Training, or ASLET, ILETA, which is International Law Enforcement Educators and Trainers Association, which I still teach at. I've taught for the Performance Institute at Washington, D.C., a variety of different state conferences as well.
Have you authored any articles on nationally recognized police practices?
Yes, I was a freelance writer for about 15 years. I worked for all the major law enforcement periodicals, Police Magazine, Law Officer Magazine, Law and Order, Tactical Response, a variety of different periodicals.
What are some of the topics that you've authored articles on with respect to those periodicals?
Primarily on my topic area, use of force, firearms and tactics.
Are those articles that you've authored relied upon by other experts in your industry?
Yeah, yes, I'm sorry. ILETA especially, I publish in the Journal, which is their online newsletter to ILETA members, which go out to all law enforcement trainers in the organization.
Thank you, Mr. Davis. I want to talk to you about your training with respect to use of force and how it relates to human factors. Do you examine human factors when analyzing a use of force?
Yes, this is a kind of a growing subject area, and since I've been in law enforcement, it has increased in the scientific research that's been applied, as well as our understanding, basically human factors or the relationship between the human being, the officer in this case, or others it can be, but as they relate to the outside world, to stimulus, as well as internal things like how the body functions under stress, our understanding of time and distance, et cetera.
Have you yourself reviewed studies on human factors
Oh, yes,
and as they relate to uses of force?
that's correct.
Have you yourself developed coursework with respect to human factors that you have since trained other officers on?
Yes, over the years, as I said, that's increased tremendously.
Can you tell the ladies and gentlemen of the jury why that specifically is important?
Well, it explains many things, everything from how far a subject can cover a certain amount of distance to how the eyes work under stress and in low light conditions, to our understanding of how the body works. What we used to call fight or flight is really our understanding of sympathetic nervous system reaction, or how the body reacts to stimulus when it feels fear.
Now, you mentioned to the members of the jury ILETA. Do you belong to that professional organization?
I do, yes.
Have you ever received any awards or been recognized in the field of use of force?
Yes, in 2018, I was the recipient of the State of Ohio Attorney General's Distinguished Training Award, and in 2019, I was inducted into the National Law Enforcement Hall of Fame as Trainer of the Year.
Thank you, Mr. Davis. Do you take continuing education with respect to law enforcement topics?
Oh, yes.
Why is that?
Well, as I said, the field is advancing tremendously, and in order to stay ahead of the topic area, you have to go to training conferences and seminars and learn the newest research, et cetera.
Understood. You mentioned earlier that you own a consulting business. What does a consultant do?
A variety of different things, help agencies develop policy and procedure, consult with law departments for different cities, look at situations or incidents and review them for agencies and consult on whether that, in my opinion, is a good use of force or within the law, or use of force that's outside of the law, as well as provide expert testimony in those cases.
And have you done all that with respect to your consulting business?
I have, yes.
And how long, sir, have you owned your own business?
In one form or another, more than 25 years.
Have you testified before as an expert in nationally recognized police practices?
I have, yes.
How about use of force?
Yes.
What about in municipal court?
Yes.
What about in common police court?
Throughout Ohio, everywhere from Colga County to Scioto County, throughout the state.
How about federally, sir?
Yes.
Have you been declared an expert in those various courts that we just discussed?
I have, yes.
Have you testified in other states?
Yes, a variety of states from Colorado through Georgia.
And have you been declared an expert when you go to those other states with respect to law enforcement and use of force?
I have, yes.
Your Honor, at this time, the defense moves to qualify Mr. Davis as an expert witness of nationally recognized police practices.
No objection, Your Honor.
All right. The record shall so reflect.
Thank you, Your Honor. Mr. Davis, I want to talk to you about the general process that you follow when determining to take a case as a consultant. Is there a process?
There is, yes. It varies in complexity. For instance, this case, the amount of material that was delivered to me was in a 1 terabyte external drive. It was a very large file.
So what is that process that you typically go through for determining whether or not to take a case outside of information?
Well, everything from the initial response or the nature of the call as developed. What I try to develop is what's called totality of the circumstances, or the total picture that the officer was involved in at the time of the use of force.
Have you reviewed cases on use of force and decided not to take them as a consultant?
Yes, I have.
Why is that?
They, as I said earlier, they were outside the legal standards, in my opinion, of what an officer could or could not do.
Based on your review of information, do you form a basic opinion?
I do, yes.
And as information continues to trickle in, do you continue to evaluate and assess your information and compare it to what your original opinion may have been?
Yes,
Are you paid for your time, sir?
I am.
How much are you paid for your time?
$250 an hour in this case.
Is that industry standard?
It's cheaper than a lot of experts charge.
I want to turn now, Mr. Davis, to discuss this case. Did you follow the same process that we just discussed with respect to this case here at hand?
I did, yes.
When was the first time, or just generally, the first time that I made contact with you about this case?
Well, I believe it was early 2022. You know, the exact date I'm not sure about. Somewhere before May, I believe.
And did I get you the initial material that you needed to come to an opinion in this case?
Oftentimes in discovery, I get the case and the material comes in, as the counselor said, in a trickle form. And I did not receive the terabyte drive until September of 2022.
In that terabyte, did you receive all of the information that you needed to come to an opinion in this case?
I never testified that I received all of the information. That's dependent on others, but I did review the information that was provided to me.
And it was enough to form an opinion for this case?
That is correct.
What specifically did I ask you to do, sir?
Review the material. We first provide an oral opinion, and then if we go forward, then a written report is commissioned, and I go about preparing a written report.
And did you prepare a report based on the information that was provided to you in this case?
I did, yes.
Would it assist you, sir, to have your report in front of you while we discuss your opinions to refer back to it?
Please.
May I approach the witness, Your Honor?
You may.
Let the record reflect that I am approaching the witness with what has been previously identified for identification purposes only as Defendant's Exhibits 11 and 12. Sir, would you take a look at those documents? Let's start with Exhibit 11. Can you tell the ladies and gentlemen of the jury what Exhibit 11 is?
This is my CV or curriculum vita or vitae. It's basically a legal resume, my background.
Now, we went over, we just highlighted some of those portions of your CV for the members of the jury, but that's certainly not all of your all of the qualifications. Is that correct?
That's correct.
What about Defendant's Exhibit 12, sir? Can you tell the ladies and gentlemen of the jury what that is?
This is my written report that I did in preparation for this case.
And was that the written report in its entirety? You were flipping through a lot of pages there.
It is, yes.
Is it a fair and accurate copy of the report that you submitted as a consultant in this case?
It is, yes.
Mr. Davis, did you come to an opinion in this case?
I did, yes.
Now, before we get to that opinion, I want to talk about how you came to your opinion and the authority that you used to come to your opinion. Specifically, sir, what did you base your opinion on?
Well, the legal standards as they apply to police officers and use of force, the real guiding legal standard is Graham v. Connor, but there are other legal standards, Tennessee versus Garner, State v. White in the state of Ohio, and other lower court decisions.
You're naming cases. Why are you naming cases, sir?
That's what's taught to basic academy cadets and in-service officers in the state of Ohio. And these are the legal standards that apply to the officers in the performance of their duties, specifically when we talk about use of force.
So is that the methodology you use when determining an opinion?
That's the basic, because that forms the foundation for the use of force. And then other issues, we talked about human factors and other issues that I involve.
You talked about the parameters, and you mentioned a case called Graham v. Connor. What are the parameters by which Graham sets up for experts to review a use of force?
Well, Graham was the first time that the Supreme Court looked at the use of non-deadly force. Prior to that, Tennessee versus Garner looked at police use of deadly force. So those two cases are pretty much hand in hand. The Tennessee versus Garner case applied the Fourth Amendment, as did the Supreme Court in Graham. And what that means is that they consider use of force, whether non-deadly or deadly, a seizure. And because of the seizure element, the Fourth Amendment applies, and the standard for that Fourth Amendment is objective reasonableness. Have
you heard of the Graham factors, sir?
I have, yes.
Can you tell the ladies and gentlemen of the jury what the Graham factors are?
This is a non-exhaustive list, as they say in State v. White, but it's the severity of the crime at issue, how severe the crime is, whether there was an immediate threat posed to the officer or others, whether the suspect was actively resisting arrest, and number 4 was the suspect attempting to flee arrest.
Now, you mentioned State v. White. Why are you talking about State v. White, and what's its significance here?
Well, there's several different, it was the first time that the Supreme Court looked at Graham v. Connor and applied it to a criminal case in Ohio. Throughout courts that I've testified in throughout the United States, some courts don't apply Graham v. Connor because it was a civil case, and they said it doesn't apply to criminal cases. In State v. White, they applied the Graham standard in Tennessee versus Garner, the objective reasonableness test, to all use of force within the state of Ohio, deadly or non-deadly. And more importantly about this case is that State v. White involved a subject who was shot by police officers who did not have a firearm.
So was that officer mistaken in State v. White?
He was.
And sir, what do nationally recognized police practices say about an officer being mistaken?
Well, it's tough when we talk about national police standards because there's roughly 18,000 different agencies within the United States and about 800,000 officers, less than that nowadays, so that there is no set standard. But when we apply the constitutional standards, those are across the board throughout the United States.
And what do those standards say about whether an officer is allowed or not allowed to be mistaken?
Objection, Your Honor.
All right. Excuse us, ladies and gentlemen. Counsel, please approach. The objection's overruled. You may inquire.
Thank you very much, Your Honor. Mr. Davis, if you recall, we were talking about mistake. Do you train officers with respect to mistake?
Yes, that's part of the decision-making process, and unfortunately, as the Supreme Court said in Graham v. Connor, that officers are oftentimes forced to make decisions in circumstances that are tense, uncertain, and rapidly evolving. So yes, that officers can and do make mistakes.
So with respect to this case, sir, did you come to an opinion of whether or not Adam Coy's use of force was consistent with nationally recognized police practices?
I did, yes.
And did you use the same principles and methods that we just talked about in coming to your conclusion as you do in every case?
I did, yes.
And is your opinion, sir, based on a reasonable degree of professional certainty when it comes to whether this use of force is in fact consistent with nationally recognized police practices?
It is, yes.
And what is that opinion, sir?
That Officer Coy's use of deadly force at the moment that it was used was what a reasonably prudent and well-trained officer.
Objection, Your Honor.
All right. Come on back just for a second. Excuse us again, ladies and gentlemen. See everyone back in about 15 minutes. We're adjourned for now.
Mr. Davis use the restroom. He's got to use the restroom. May he use the restroom?
Yes.
Yeah.
Oh.
All rise for the jury.
May be seated, ladies and gentlemen. All right. Ms. Stevens, if you rephrase.
Thank you very much, Your Honor. Sir, your opinion in this case is that Adam Coy's use of deadly force is consistent with nationally recognized police practices. Is that correct?
That is correct, yes.
I want to talk about how you came to that opinion. What exactly did you examine first in coming to the opinion that his use of force was within nationally recognized police practices?
Well, I think I first reviewed his statements and his partner's statement, Officer Detweiler's, and then worked from there.
And what did you first determine? What did you first look at in order to determine whether or not Adam Coy's use of deadly force was consistent with nationally recognized police practices?
Looked at the nature of the call, Officer Coy's responses, the decedent Mr. Hill's actions and responses in dealing with Officer Coy, and then went into the body-worn camera evidence.
Did Officer Coy have a lawful objective for taking action here?
Yes, he was dispatched to a disturbance call, but the nature of the call was actually a suspicious person called in from a neighbor.
Sir, can you tell the ladies and gentlemen of the jury what it means when I say reasonable, articulable suspicion?
Yes, it's a legal standard in policing. There are different, there's like a timeline of officer-subject interactions. Everything from consensual stops. An officer is wanting to talk to somebody, but doesn't have anything more than, you know, I like to find out who this person is. And that's a consensual stop. If you say, "Excuse me, sir, can I talk to you?" and he stops, that's a consent. It may develop from there into reasonable, articulable suspicion that a crime has been, is being, or about to be committed. And then from there, that may develop into probable cause to make an arrest.
Is reasonable, articulable suspicion a nationally recognized police practice?
Oh, yes.
What is an officer trained to do when they have reasonable, articulable suspicion?
Well, there's a variety of different responses that an officer can use, but an officer can detain a person. That would be what's called a Terry stop. Based on reasonable suspicion, you can stop the person. From there, it may develop into a Terry search or pat down of the outer garments for weapons. That comes from Terry versus Ohio. So, as I said, it's based on articulable suspicion that a crime has been, is being, or about to be committed.
If an officer has a reasonable, articulable suspicion, do they have to investigate?
That's an officer's obligation to respond to the call and to develop the call, to investigate, and to interview the person as reasonable suspicion is developed. And yes, they would have an obligation to deal with the subject.
So did Adam Coy have a reasonable, articulable suspicion in this case?
I believe so, yes.
Why is that?
I believe the decedent Mr. Hill's actions developed, based on everything. That's totality, the circumstances, the time of the morning. It was after 1:35 in the morning. The fact that a neighbor called in and said, "Hey, this is a suspicious vehicle, was idling here, turning on and off, and then moved up in several spaces on the street and parked." And then, based on the responses of Mr. Hill to the contact, everything from leaning out of the window and showing his cell phone to going up to the house, banging on the door, no one responded to the door, and then going back, leaning into his vehicle, and then going back towards the house. So all of that combined is totality of the circumstances, which, once again, would lead to reasonable suspicion.
What kind of reasonable suspicion does a trained officer observing these things have? How is an officer trained to perceive these actions?
Well, there's everything. The subject's demeanor, nervousness can be one. You know, Mr. Hill was described as being fidgety and wide-eyed, and, you know, from his behaviors and showing the phone as if blocking the interior of the SUV was driving, going up to the house, knocking loudly on the house, saying he was waiting for someone and no one came to the door, no lights came on, coming back, leaning into the vehicle again, and then going back up, you know, towards the house where Officer Coy lost sight of him.
So did Officer Coy have to stay and observe what was going on?
Yes, that would be prudent police work.
Would that be consistent with nationally recognized police practices?
Oh, yes.
Okay, I want to talk about the timing of this event, sir. Did you analyze the timing of this use of deadly force?
The actual application of the use of deadly force, the entire call as it transpired from the body-worn camera that was turned on by Officer Coy, and then, yes, as to the amount of time of the deadly force encounter.
Do you examine how quickly events transpire when analyzing a use of deadly force?
Time is an issue, especially when an officer doesn't have time to make a step back and make a reflective decision or take, you know, other steps. In other words, if the subject or suspect creates what the Supreme Court said is tense, uncertain, and rapidly evolving, the higher that is, then the more stress is placed on an officer in making decisions.
And did you find that these circumstances were rapidly evolving and tense and uncertain?
Yes.
You mentioned you analyzed the body-worn camera. Can you talk the ladies and gentlemen of the jury through the timing of the body-worn camera with respect to the approaching Mr. Hill in the garage?
Yes, I was a detective in the body-worn camera unit of the Akron Police Department for the last 3 years of my career, and analyzed thousands of hours of body-worn camera video. The states supplied some expert work on the video, which put what's called a timeline on the video so you can track the elapsed time, also a frame counter, but they did brighten the video. So you have to remember that that's not what Officer Coy saw. Furthermore, the camera records at a higher light level than the human eye, so that's not what Officer Coy saw. But yes, when you look at the motions by the raw body-worn camera video as well as the OOIC video with the timeline, I did analyze that, yes, and the time involved.
So could Adam Coy have walked away as he was approaching up from the drive?
I'm sorry, could Officer Coy have walked away?
Correct.
That's not what we expect of police officers. You call an officer to investigate these types of circumstances, and that's their responsibility to handle the call. So no.
Sir, how long in your analysis does it take from the time Adam Coy illuminates Andre Hill in the garage until he brings his pistol into view?
As Mr. Hill is walking towards him, there's roughly about 3 seconds that transpire from the time that Mr. Hill begins to move until we can see the pistol come up into the frame of the BWC.
At the time he used deadly force, Mr. Davis, should Officer Coy have asked additional questions?
See, the problem with talking in those types of circumstances is, as human beings, we're not very capable of doing multiple things at the same time. For instance, when you pull up to an ATM, you turn the volume of your stereo down. Why? So you can attend to the ATM, you can focus. As human beings, we do the same thing. When we talk, we're thinking about talking or challenging or giving verbal commands. In that, we slow our reaction or response time when we talk. So verbal commands, if Officer Hill felt threatened with death or serious bodily injury, were not required.
What do nationally recognized police practices train an officer in with respect to perceiving a deadly threat?
That deadly force is appropriate. A variety of other options could be used. For instance, moving, but if the officer perceives that his life's in danger, then deadly force is appropriate.
And that's with regards to nationally recognized police practices?
That is correct.
You mentioned earlier about the Graham factors. Did you analyze these in coming to your opinion that Adam Coy was in fact consistent with nationally recognized police practices?
I did, yes.
What are the Graham factors again, sir?
First of all, the severity of the crime, and these aren't necessarily in the order some of the lower courts have said. The next one, the immediate threat to the officer or others, is the paramount thing. Severity of the crime, whether the subject is actively resisting arrest or attempting to evade arrest by flight. But that's not an exclusive list.
I understand. I want to take those factors one by one, however. You talked about the severity of the crime at issue. Tell the ladies and gentlemen of the jury what you mean by severity of the crime.
Well, severity of the crime is not what the original call was. In this case, it was a disturbance call or a suspicious person, suspicious vehicle. That's not the severity of the crime. The severity of crime is at the moment the officer uses force. For instance, an officer can be trying to arrest a jaywalker in the downtown area, and the jaywalker pulls a gun on the officer. The severity of the crime is that action, the attempted murder or felonious assault of the police officer.
Is there any more severe of a crime than when a suspect levels a gun at a police officer?
Other than being shot at, no.
How do national police standards teach officers to respond in that situation?
Once again, in these tense, uncertain, and rapidly evolving circumstance where they fear that their life or the life of another is being threatened with death or serious bodily harm, then deadly force response by the officer is appropriate.
Do national police standards mandate that an officer have to be 100% sure before responding with deadly force?
No, unfortunately, what we were talking about is something called action response time. When a subject, for instance, with a clear-cut gun down behind their thigh or at the low ready or pointing at the ground, if an officer waits until the gun is leveled or the gun is fired, the officer is going to lose because of the response time lag. In other words, I can do this in about 1/3 of a second. That's all it takes for an officer or for a subject to raise and fire an officer. In truth, just as I've handled cases or dealt with cases where just a shift of the hand, a subject fired at an officer, that was even less than 1/3 of a second.
So are police officers trained with respect to subject reaction time?
Yes, it's a big part. Subjects armed with knives, what they call the 21-foot theory with subjects armed with knives, that they can run 21 feet in about 1.5 seconds, and that's about the time it takes an officer to draw and fire one round. That is commonly taught in law enforcement, as is subjects with hands in pockets, hands secreted, anything, anytime that the subject makes a motion, etc. Those are all taught in law enforcement, basic and in-service training.
But sir, we know that Mr. Hill was not armed with a firearm here. Does that matter?
Of course it matters and it's tragic, but the question is, at the moment the officer used force, based on his reasonable perception, was it within the law, looking at the totality of the circumstances?
So does the fact that he actually did not possess a weapon, does that come into your analysis?
Only in that we know that in hindsight. In other words, after the shooting transpired, this is when Officer Coy saw the keys. Up until that point in time, Officer Coy, in my belief, reasonably believed that Mr. Hill was armed with a gun.
What do you base that part of your opinion on?
Well, the totality of the circumstances, once again, this shooting, like many mistake of fact shootings, took place in low light. And that's not the officers doing, that's just the circumstances. But in low light, our visual field narrows and also changes. We have rods and cones in our eyes. The rods are used, the central vision are used for low light circumstances, but they're not very precise. Also, our use of...
Objection, Your Honor.
Overruled.
Thank you.
Okay.
Also, our ability to see color is diminished in low light circumstances. I stated before that the body-worn camera is a reflection of what the camera saw, but not what Officer Coy saw or was able to see, even with the use of the flashlight.
So you just mentioned an important term, hindsight. Are you allowed to use hindsight in your analysis with respect to whether or not an officer complied with nationally recognized police practices?
No, in both Graham versus Connor, as well as State v. White here in Ohio, the courts have specifically said that it's to be viewed from the perspective of the involved officer, not in the 20/20 vision of hindsight.
And we just talked about that first Graham factor, severity of the crime. I want to move to the second Graham factor that you mentioned, whether the suspect poses an immediate threat. How did you analyze this factor with respect to this case?
Well, the response is we don't have, although the body-worn camera was activated after the shooting, we have that look back. It corroborates the statements made by Officer Coy and subsequent in the interviews.
So did you find that the suspect posed an immediate threat here in this case?
I found that based on my opinion that it seemed that Officer Coy's perceptions were reasonable based on the circumstances.
And is that with respect to nationally recognized police practices?
That is correct.
I want to move on to the third factor, sir, whether the suspect is attempting to evade. What did you find with respect to that factor?
Well, Mr. Hill was walking towards Officer Coy at that time, but prior to that, it was Officer Coy's statement that he lost sight of Mr. Hill, and he believed that Mr. Hill went around the house to the rear of the house at that time.
So did you find that he was actively trying to avoid arrest or evade detection?
It was rather interesting that Officer Coy stated that he tried to hail Mr. Hill as he walked the second time towards the house, but Mr. Hill just looked over him, didn't respond, and didn't stop, etc.
You talked briefly about the body-worn camera here in this incident that you analyzed. Are there any other limitations for the body-worn camera when reviewing a use of deadly force?
Oh, yes. Unfortunately, based on technology, and we watch TV and movies, we tend to believe what we see, what the camera shows us, but in reality, that's not the human eye. There are limitations to the camera. For instance, these videos were shot at about 30 frames per second, which means that the camera takes pictures, individual pictures, at 30 frames per second. That looks like it's continuous, but really on a camera, the only thing that is continuous is the audio. Everything else is segmented, as I said, 30 frames per second. The camera also distorts images at the edges because it has a fisheye lens. And because of that, there's some distortion. As I said, it's the camera picks up more light than the human eye does, so that doesn't accurately reflect what the officers involved see, especially at night. And then the camera, the digital system, is designed to save space on the drive. So it uses what's called I-frames or B-frames. And what that does is if something in the image, something within the camera doesn't move fast enough, then the camera recreates that same image or recreates portions of it. So otherwise the drive on the camera would have to be huge. So it's kind of an interesting way that the camera works. So we have to understand the limitations. And it also doesn't pick up if an officer is in contact with somebody, doesn't feel what the officer feel, or what we call resistive tension. So there are limitations in the camera systems.
How do you account for those limitations in coming to a conclusion?
Well, the camera is only one piece of the evidence. It's you have to look at the totality of the circumstances, the facts, the evidence as are recovered or discovered in the investigation. You can't just solely rely on the video.
Does the body-worn camera take into account human factors that you discussed earlier?
Oh, no. Matter of fact, one of the problems with the camera is that it tends to project images that are actually further away than the camera portrays, that because of the two-dimensional image, it looks closer than it actually is.
What human factors did you analyze here in this case?
Well, the biggest part of this case is the aspects of low light and human vision. That's the biggest thing because of the limitations of what Officer Coy could see. And the next thing would be action response time, that once he perceived what he believed was a silver revolver held in Mr. Hill's hand, the time it would take for him to react and respond. So an action, as I said, is always faster than response time.
I want to talk about that second principle. You said an action is always faster than a response time. Are officers trained on this?
Oh, yes. It's become a big part of police basic academy and in-service training.
Can you tell the ladies and gentlemen of the jury why it's important to take action versus reaction into your consideration when analyzing perceived threats?
The officer's decision to take action, and any decision, is based on the totality of the circumstances. And in a well-lit day out on the sidewalk, on a day like today, when an officer has the ability to see everything or see as much as he can, even then we have limitations with human vision. But with action, as I said, just the pointing of a gun is so quick that an officer doesn't have time. If he is attentive to the subject, then it's going to be the time it takes for him to begin or to download a mental response, in other words, drawing a pistol. Then there's the movement time, the time from the beginning of the draw to the extension of the arm or arms and the press of the trigger. That's movement time. So we put reaction time with movement time, and it's significantly longer than the subject's time to just act.
Do nationally recognized police practices take into consideration threat patterns?
Yes, we teach officers in basic academy to develop a mental shortcut. Now, we can't do that on the range with live fire because we don't have animated targets. We're not that sophisticated. But in the training process, officers are exposed to virtual simulators like FAT systems or Virtua systems that are basically movie screens that the officer responds to and shoots a non-firearm, essentially a laser at the screen simulating gunfire. So we try, and then that's coupled with usually confrontation simulation training, where officers deal with role players that are suited up to protect their face and eyes, and we have non-deadly, what's called marking cartridges, essentially very expensive paint rounds that fire out of realistic firearms, and these are used by role players and the officers.
So how are officers trained with respect to threat identification and threat patterns?
Well, we tried to teach them what it looks like to draw. I mean, this isn't like a gunfight at the OK Corral where the bad guy's got a holstered gun, the sheriff has a holstered gun, and that doesn't happen. So we go off where suspects normally secrete firearms and how suspects on the street act and attack officers with firearms.
How do suspects on the street typically attack officers with firearms?
Usually it's a one-hand point and shoot.
Where is that firearm kept typically?
Well, everything from secreted on the subject, usually the abdominal area, the front of the waistband, but subjects have secreted firearms in their pockets. Officers say, "Excuse me, sir, can you take your hands out of your pocket?" Subject draws a gun and shoots the officer. Everything to hiding the gun behind their thigh or down, trying to obscure the view of the officer. That can be in a car, it can be on foot, etc.
And so when an officer is approaching a suspect who he believes to be armed, is that what they're looking for?
The hands. What we teach officers is to watch the hands, and because what's in the hands is what's going to kill or assault officers.
Sir, do you know what perceptual narrowing is?
I do, yes.
What does that mean?
With stress, and there's a variety of different ways the body and the brain and the eyes work, is that we normally have a very wide visual field, but in stress, things narrow down because this over here is not important and this is not important by the brain. So we focus into about a 10-degree arc of vision, and that's perceptual narrowing. The eyes are seeing it, but the brain is not registering it.
So was that taken into your account here with respect to the use of deadly force?
Oh, yes, tunnel vision and perceptual narrowing by the eyes was definitely taken into effect or taken into consideration.
Why is that?
Because once again, the officer is focusing in, Officer Coy is focusing in on what he perceives as a threat.
Okay. I want to talk about the environment within the realm of the totality of the circumstances. You mentioned the low lighting, but are additional environmental considerations taken into account?
Well, this can be, the presence of other potential suspects, violent nature of calls, all that is looked at in an analysis.
With respect to the lighting, sir, what did you find with respect to this use of deadly force?
This is what we would call adverse lighting. In other words, the floodlights at it would be the southwest corner of the house illuminated the driveway, so the officers were illuminated as they walked up the driveway, but Mr. Hill was not illuminated in the depth of the garage. Even with the flashlight, very hard to see him penetrate into the darkness to see what Mr. Hill has in his hands or what he's doing.
Did you analyze tactics here?
Yes, always.
What tactics specifically did you examine?
Well, the approach, the way the call was handled by Officer Coy and Detweiler, the approach to Mr. Hill, and then the tactics involved with the actual confrontation.
And did you find that the tactics in this case that were taken were consistent with nationally recognized police practices?
Yes, there are no specific answers. The Supreme Court has said that use of force is incapable of precise definition or mechanical application. What we look at is a range of things. And first of all, this was lawful. What Officer Coy and Detweiler did was within the law in terms of the way they approached Mr. Hill. Then we looked at, do average officers, is this a range of behavior? And it certainly is, in my experience as well.
Have you reviewed the state expert report by Seth Stoughton?
I did, yes.
What did you find with respect to that report?
I know Mr. Stoughton. I believe that he uses a lot of what I call constructs. For instance, he uses opportunity, jeopardy, and apparent intent as a construct to formulate his opinion. And he also focuses on what I would call hindsight bias. In other words, we know the outcome that Mr. Hill had a set of keys in his hand and not a handgun. But Professor Stoughton looks backward and from that hindsight bias makes the determination that the activities of the officer created jeopardy, which led to the shooting.
Is that consistent with nationally recognized police practices, what Professor Stoughton does?
No, officer-created jeopardy is specifically precluded in Graham v. Connor because it says that we shouldn't look at officers' use of force 20/20 hindsight. But in State v. White, it clearly says that even the most erudite police practices expert shouldn't count rearward-looking hindsight as to what the officer could have, should have, or might have done.
And why is that important?
Because we're supposed to judge an officer's use of any force from their perspective, not what Mr. Stoughton believes based on his office.
You said from their perspective, so whose perspective are you supposed to look at?
Officer Coy's perspective.
And what did you find, sir, with respect to Officer Coy's perspective with regards to whether or not his perspective and his use of deadly force complied with nationally recognized police practices?
I believe that based on his statement that he reasonably believed that Mr. Hill presented the threat of death or serious bodily harm and that the use of deadly force was within the standards in law enforcement.
Even though he was mistaken?
Even though he was mistaken. Tragically, but even though he was mistaken.
May I have a moment, Your Honor?
You may.
Thank you, Mr. Davis. I have no further questions for you at this time. I'm sure Mr. Pearson has some questions for you, though.
Thank you.
Thank you, Ms. Stevens. Cross-examination?
Thank you, Your Honor.
Good afternoon, Mr. Davis.
Good afternoon, Counselor.
Good to see you again.
Nice to see you as well.
You teach use of force curriculum, is that correct?
I do, yes.
Okay. You teach it in various areas, looks like in the Midwest, is that right?
Wherever national conferences are held, it's tended to be in the Midwest, but it can be other places.
You teach this to law enforcement officers?
I do, yes, as well as labor associations, et cetera.
Okay. And you teach, though, in those teachings, you teach officers essentially the law of what you feel it is with respect to officer-involved shootings, is that right?
Well, I teach them and point them in the direction of the legal standards, yes.
Okay. And you teach them what constitutes a quote-unquote bad shooting, correct?
I don't know that that is a curriculum. I look at what is within the law and what is outside the law.
So you teach these students what is within the law for officer-involved shootings?
I teach them to examine and apply the legal standards to officer-involved shootings, yes.
And you teach them what is outside of the law with respect to officer-involved shootings, is that right?
I think I've covered excessive use of deadly force, so yes.
And you teach them about the various factors that need to be taken into account when deadly force is used?
There's a variety of different areas in that topic.
So do you teach them about those areas?
If you're asking about the Graham factors, or in addition to the Graham factors, yes.
So you teach these officers about the need for a severity of crime, like the need to analyze that?
That's one of the Graham factors, that's correct.
And the suspect actively resisting arrest, you talk to your students about how that's important?
Yes,
You talk to them about whether there's an immediate threat and why that is important in an officer-involved shooting?
yes,
And whether the suspect is fleeing or not. You talk to them, talk to your students about the importance of that, is that right?
that amongst, as I said, many other topic areas. It's not an exhaustive list in Graham.
Okay. You referenced case law in your discussion with the defense counsel. Do you recall that?
I do, yes.
Yes. You're not a legal expert, are you?
No, I'm an expert on the use of force investigations.
Okay, and you've never gone to law school, correct?
No,
Not an attorney, correct?
that is correct.
You rely heavily on Graham v. Connor and State versus White. Those are the two cases that you have mentioned, is that right?
In my testimony,
Yes, in your testimony.
I've mentioned Tennessee versus Garner. There are also a multitude of lower court decisions.
Okay. Do you recall when Graham versus Connor was decided?
Graham was decided in 1989.
Okay, so about 35 years ago. Is that right?
I'll trust your math, Counselor.
About 30, it
It's not-
was about 35 years ago, right?
Yes, it's fine.
Okay. Do you know how many cases have applied Graham v. Connor, either applying it, altering it, overruling it? Do you know how many cases have done that?
By the Supreme Court or
Right.
lower courts?
Any courts?
I wouldn't be able to keep track of that, Counselor.
Okay, so if I said over 500 decisions from courts that either alter its application, change its application, or uphold its application, you wouldn't have any reason to dispute that, would you?
No, I have no basis for that.
Okay, and just to be clear, you haven't read all of those cases and those various applications, have you?
No, there's enough cases that I have read.
All right, with respect to State v. White, do you recall when that case was decided?
I don't, Counselor, offhand.
Okay. Do you recall that it was a 2010 case? That incident happened in 2010?
I'll take your word for that.
Okay. Do you recall how many cases have cited that decision, affirmed that decision, disputed that decision, or had various applications of that decision?
In Erie, Ohio, no, I wouldn't know that.
Okay. Would it surprise you that it's upwards of 300 cases?
Based on my testimony and using citing State v. White, I wouldn't be surprised.
Okay. And again, you have not read all of those cases and those various applications, have you?
No, I have not.
And since you rely so heavily on these cases and that there have been lots of applications of it, those cases, if those applications were different, or there are some varying applications of those cases, could that possibly change your opinion and analysis here?
I've testified in courts. And,
I'm sorry, sir.
Sorry, I'm answering a question.
You may be answering a question, but my question is yes or no. Would that change your decision?
That wasn't your question, but yes, that would change. No, not in the application of State v. White, but no, I don't know that.
So your answer is you don't know?
My answer is, in terms of the application of State v. White, no, that would not change.
All right. You also rely heavily on Officer Coy's statement, Mr. Coy's statement, don't you, in making your determination?
I do, yes.
So if there are things that are different in his statement versus what really happened, that could change your analysis, couldn't it?
Can you describe what really happened?
If there is a item in Mr. Coy's statement that is different than what you have, couldn't that have an effect on your analysis?
I've not been afforded the opportunity to review that, so I'd have to review the item and make a decision.
Okay. So it sounds like your answer is either yes or no, depending on the item that is different. Is that accurate?
Well, afforded the ability to analyze it, yes.
Okay. So it could have an impact on your analysis and decision.
It could, depending on the item.
Walking through your report, you stated that Hill posed an immediate threat to officers or others. Didn't you write that?
Can you refer me to a page and paragraph?
I believe page 12. I do not have a paragraph for you.
The topic area, in answer to your question, is examining the gram factors, whether the suspect posed an immediate threat to the officers or others. And my response was based on Officer Coy's perceptions as listed in his statement.
So I guess I'll ask you a more direct question. Did Hill pose an immediate threat to Officer Coy?
I believe that Officer Coy perceived and was reasonable in his perceptions that Mr. Hill did, yes.
Okay, so you answered a question, but you didn't answer my question. My question was, did Hill pose an immediate threat to Adam Coy?
In hindsight, we know it was a set of keys, so no.
Okay, so your answer is no to that question.
My answer is, in hindsight, based on what we know after the shooting, that he did not, in fact, have a handgun.
Okay. Hill did not have a weapon, you recognize, correct?
That is correct.
And according to the defendant's statement that you relied on, Hill never made any intention that he was going to perform a violent act. Isn't that correct?
There was no articulated threats by Mr. Hill, no.
Okay. And Hill was not committing any crime, correct?
I don't believe so. I don't think
All right,
anything was.
thank you. I have another question for you. You had talked about, where was it? you had talked about the three, essentially three stages of police-civilian interaction. You talked about a consensual stop, reasonable articulable suspicion, and probable cause to make an arrest. Do you recall that?
Consensual stop, reasonable suspicion, probable cause, correct.
Can you talk about those again, please? Essentially define or tell me what they are.
Well, once again, officers in the performance of their duties come into contact with subjects every single day. Many of those encounters are consensual. An officer, say, is proactively, he's downtown and he wants to check out a subject that's bothering pedestrians, et cetera, like a panhandler. The officer can go up and say, "Excuse me, sir, can I talk to you for a minute?" If the subject stops, that's a consensual stop. They can engage in contact. It can develop into reasonable suspicion or probable cause from there, but it's consensual in nature. If the officer believes that a crime has been, is being, or about to be committed, then the officer has reasonable suspicion. He can go up to the person and say, "Excuse me, I need to talk to you." And if the person tries to move away or walk away, then he can use force to detain him, all right? Based on his feelings that weapons may be involved, he can even do what's called a Terry pat down of outer garments for weapons. And then finally, if he observes the probable cause, that elements of the crime, that crime has been committed, then he can stop the subject, use force to detain him, handcuff him, and place him under arrest.
Okay. And none of the interactions between Adam Coy, Mr. Coy, and Andre Hill, was there a probable cause to make an arrest, correct?
I believe there was the probable cause to believe that Mr. Hill presented a threat of death or serious bodily harm.
Okay, again, you're answering a question that I didn't ask. My question was, do you believe that there was probable cause at any point?
Objection, Your Honor.
Overruled.
Do you believe that there was probable cause at any point to arrest Mr. Hill?
I believe he had, as I said, probable cause to believe his life was in danger.
Your Honor, I'm going to ask that you direct the witness to answer my question.
Okay, to the best of your ability, the question is, do you believe there was probable cause at any point to arrest Mr. Hill?
I didn't see elements of the crime, so no probable cause to arrest.
Thank you. And when we talk about consensual stops and a reasonable articulable suspicion, you talk about consensual from the officer's point of view. That's how you've described it here in this courtroom today, correct?
Well, that would be whether the subject consented, so it would be the perception of the officer and the subject's behavior or statements.
Is a subject allowed to walk away from a consensual encounter with a police officer during a consensual stop?
Yes, as I stated before, if the officer doesn't have reasonable suspicion or probable cause, then the subject can walk away.
Okay. They can end that conversation and walk away. Is that correct?
Correct.
No individual has an obligation to talk to police officers on a consensual stop basis. Isn't that accurate?
On a consensual stop, no.
What about reasonable suspicion?
As I stated earlier, reasonable suspicion that a crime has been, is being, or about to be committed, then the officer can use force to stop the subject.
You stated in your report and also in testimony here today that the importance of watching an individual's hands. Do you recall that questioning from defense counsel?
I did, yes.
Okay, so you would agree that it's important if an officer is concerned that an individual may have a weapon, that an officer is to watch the hands.
Yes, I think that's for officer safety, which is paramount in these encounters, that the officer watch the hands to the degree that they can and control the suspect's movement.
And also, I guess added to that, if an officer wants to see an individual's hands that they can't see, an officer can simply ask to see their hands. Isn't that correct?
Ask or order, depending on the circumstances, yes.
All right. You also stated in your report on page 19 that when confronting an individual, police officers are taught to maintain as much of a reactionary distance between themselves and the person as feasible. Do you recall writing that?
Yes.
Okay. Why is that important, Mr. Davis?
Well, to the degree possible, oftentimes officers are responding to a subject's actions. They can't control the subject, and we teach the reactionary gap as much as possible to maintain a safe distance away from a subject to give them time to be able to respond should an assault occur.
Okay. And that reactionary distance is dependent on the facts and circumstances, correct?
Correct. If, for instance, the officer is confronting somebody with a long gun, like a rifle, that would be as much distance as the officer can manage. If, in other circumstances, handgun, once again, further distance, but just dealing with subjects on the street, the average reactionary gap, as we teach in the basic academies, is about 6 feet.
Okay. So you talk about also that the video that the body-worn camera that you viewed of the shooting and killing of Andre Hill is not, I guess, accurate to what Mr. Coy saw, correct?
Oh, that's absolutely true, yes.
Okay. And you indicate that the video may actually have better lighting, lighting enhanced, is that correct?
Well, there's two different videos. There is this, just a basic unedited BWC video from Officer Coy. That has increased light capabilities more than Officer Coy's eyes. And the OOIC video has specifically been enhanced.
Okay. Speaking of body-worn camera, according to generally recognized police practices, back in 2020, when should an officer turn on their body-worn camera?
It depends on policy and procedure of the agency.
Okay, well, I'm not talking about policy and procedures. I'm talking about generally recognized police practices. So are you saying that were none?
There's really none in terms of body-worn cameras. Since then, there's a multitude because of the
Thank you,
amount-
Mr. Davis. You've answered my question. I'm going to move on to the next question.
Your Honor, I would ask that
Okay, hold on. All right. Let the witness finish responding to the question that was asked.
Because of the large amount of interactions that officers have with subjects and the amount of digital video evidence that's being produced from these cameras, agencies throughout the country have applied different things. Some agencies, when you first get the call, you turn it on. Some agencies, when you get out of the car, you turn it on. Some agencies, when an arrest is being made, you turn the camera on. So there's a multitude of different, BWC policies. There's no standard.
You go on to define danger cues, I believe on page 36 of your report.
Refer me to a paragraph, Counselor.
I do not have a paragraph, sir.
It's the last paragraph, Counselor, so I have it. Go ahead.
Okay, so you teach your officers that, the officers that you teach, you talk about danger cues, correct?
Danger cues are yes, but more than that, there are different types, body postures, preset body attack postures, et cetera. So yes.
Okay, so walking toward an officer could be a danger cue.
It could be, depending on the circumstance.
Walking away from an officer could also be a danger cue, correct?
Yes, I would say yes.
I guess keeping your hands concealed could be a danger cue, correct?
Certainly, as we talked about, hidden hands.
So showing an officer your hands could be a danger cue, couldn't it?
Quick movement of showing the hands, it depends on the totality of the circumstances.
Okay. Looking away from an officer could be considered a danger cue, couldn't it?
Called furtive glances or looking away, looking for other subjects, looking for other officers, looking for means of escape, so yes.
Looking at an officer can also be considered a danger cue?
Depends. I mean, people look at officers, but what's called the 1,000-yard stare can be considered a danger cue, yes.
Okay. Talking to an officer can be considered a danger cue, correct?
I don't know that I've ever heard talking to officers is a danger cue.
Well, Mr. Davis, you reference in your report that it was a cue that Mr. Hill spoke to Officer Coy before Coy addressed him as a potential danger cue, didn't you?
I don't think that was used as a danger cue perspective at the original stop. I think it was part of Officer Coy's development of reasonable suspicion in the totality of the circumstances, but no danger cue, no.
Okay, but you do agree with me that you indicate it was appropriate for Mr. Coy to take that into account as to something being out of the ordinary, the fact that Mr. Hill spoke to Mr. Coy first.
I think that was part of Officer Coy's statement to be considered in totality of the circumstances.
Can you think of anything that could not be considered a danger cue? Anything of natural human movement that really could not be considered a danger cue under any circumstances?
We deal with subjects on the street all the time, natural human movement, and no threat is perceived and no danger cue is felt, but they have to be viewed in context and they have to be viewed in the totality of the circumstances.
So would you agree with me that natural movement should not be considered a danger cue?
Depends on the circumstances. It can be based on the context.
Okay, so you would agree with me that natural movement can be considered a danger cue, correct?
Well, the officer wouldn't know. He would be going like danger cues or cues of pending danger to the officer. And that has to be perceived by the officer based on the totality of the circumstances and his reasonable perceptions.
You talked about threat, correct?
Can you refer me to a page?
I believe on page 39, you state a threat is capability to do harm joined by hostile intent.
That's a quote, but yes.
Okay. Do you accept that quote, or do you dispute that quote?
I believe that intent is hard to determine by officers because what we have is instead perceived intent, what the officer believes based on the circumstances. So capability can be based on the circumstances as well. So I have quoted that author, and I do not believe that that's unreasonable.
What is a threat according to you, Mr. Davis?
Well, that would have to be perceived by the officer, and depending on the circumstances. Different threats can be different, everything from cocking the arm back to, the threat of a punch, to suddenly reaching inside the waistband, to lifting the arm up quickly. All those can be perceived as threats based on context.
So it's up to the own individual officer to determine threat.
It is, yes.
Couple of more questions, Mr. Davis. You would agree with me that an officer can be mistaken, but also operate or be operating outside of generally recognized police practices, correct?
I think those circumstances could exist hypothetically, yes.
Okay. So just because an officer made a mistake does not mean that they are operating within generally recognized police practices, correct?
Hypothetically, again, yes.
You wrote on page 44 of your report, talking about perceived danger. And I wonder if this is a quote that you just used or a quote that you agree with, and I'll read it for you.
Please.
The perceived danger must only be apparent, not an actual danger, in order for the officer to use lethal force. Do you agree with that?
Yes, I believe if the officer believes that his life or the life of another is being threatened, then yes, he can respond with deadly force.
Okay. You also wrote that on page 29, clearly Officer Coy's tactics were within best practices in law enforcement. You agree with that? Is that your statement?
I do.
I heard you say earlier that the term generally recognized police practices is not something concrete. Is that right?
Because of the large number of agencies, every state has a training, like Ohio, we have a Ohio Peace Officer Training Commission. They develop curriculum in the training of officers. Every state has some version of that. Every agency has different policies. Every agency trains differently. So I believe trying to come up with national police standards is tough.
Looking at an officer who has used deadly force, they can be remorseful but still be operating outside of generally recognized police practices, correct?
I think that's correct.
Thank you. No further questions, Mr. Davis. Thank you.
Thank you, Counselor.
Thank you, Mr. Pearson. Redirect.
Thank you, Your Honor.
May I inquire?
You may.
Thank you. Mr. Davis, Mr. Pearson asked you about Graham v. Connor. Do you recall that?
Yes,
Is Graham v. Connor still the standard by which officers are permitted to respond with deadly force?
yes and no. In some states, for instance, Virginia being one, I've worked on cases in Virginia, although Graham v. Connor is taught in the basic academy there, in some courts, they believe it's a civil case, and so it doesn't apply to criminal matters.
Here in the state of Ohio, is Graham versus Connor still the standard by which officers are permitted to respond with deadly force pursuant to nationally recognized police practices?
That in Tennessee versus Garner, yes.
Is State v. White still the standard by which officers are permitted to use deadly force when responding to a suspect that they perceive a deadly threat by?
Yes.
Are officers still trained on State versus White?
Depending on the agency, less so in State v. White, unfortunately.
Here in the state of Ohio, are officers still trained on State v. White with respect to mistake?
Objection, Your Honor. Broad generalization.
Okay. Overruled if the witness notes.
It's now become part of the basic academy curriculum in the state of Ohio.
Are Graham and White consistent with nationally recognized police procedures?
Yes.
Mr. Pearson talked about whether the suspect posed an immediate threat. Do you recall that conversation?
I do, yes.
What are actual threats versus perceived threats?
Well, actual threats would be the suspect turns out later on to have a gun, whether the gun is recovered after the shooting or is fired at the officer. A perceived threat is up till that point, and that's determined afterwards. If no shots were fired and a shooting occurs, then we would find out that it was a perceived threat, but not an actual threat.
If an officer sees an arm leveled in their direction and they see the glint of steel, how are officers trained to respond?
based on their perceptions of the threat of death or serious bodily harm, they're trained to respond with deadly force.
Does a person have to have a weapon in order to respond with deadly force?
In order for an officer to respond?
Correct.
No,
Why is that?
because the officer is acting based on his perceptions. We have to look at whether those were reasonable perceptions based on the circumstances.
If an officer perceives a suspect coming at him with a hidden hand, can they perceive a threat there?
They can, yes.
Is that a danger cue?
It is, yes.
Is that a threat pattern that you train officers to look at in the academy?
Absolutely.
Mr. Pearson talked to you about probable cause to believe Andre Hill was committing a crime. Do you recall that conversation?
I did, yes.
Did Officer Coy have probable cause to believe that he was going to be shot on December 22nd, 2020?
Based on his statement of his perceptions, yes.
Was there a perceived deadly threat there?
Yes.
You recall the conversation Mr. Pearson had with you with respect to reactionary distance, correct?
That is correct.
Any issue with the reactionary distance that Adam Coy took here?
No, none at all.
Why is that?
Because it was, he wasn't closing in within that 6-foot distance, and Mr. Hill was the one that was moving towards him.
You had a conversation with Mr. Pearson about mistake. Do you recall that conversation?
I do, yes.
What did you find with respect to mistake here in this situation back from December 22nd of 2020?
That it was a mistake of fact shooting, that Mr. Hill did not have a gun.
And what did you find with respect to whether that mistake conformed with nationally recognized police practices and procedures?
That based on the facts, including the body-worn camera and Officer Coy's statements, that it comported with those national standards.
Thank you, Mr. Davis. I have no further questions. Oh, I apologize. Hold on. That's what I get for not asking. If I may have a moment. May I have a moment, Your Honor?
You may.
Is one of those facts that you took into consideration based on the fact that you saw pictures of a silver keychain at the scene back on December 22nd of 2020?
I'm sorry, one of the decisions that I factored in, or one of the facts I factored in? Yes, yes,
With respect to the mistake?
yes.
Thank you, Mr. Davis. I really do not have any further questions right now.
Thank you, Ms. Stevens. Recross?
Yes, just have a very short follow-up.
Mr. Davis, you talked about a perceived threat, and you indicated that anything the officers say they were threatened by. Wouldn't that be a perceived threat?
Would be based on the facts and circumstances, yes.
Okay. And if an officer perceives a threat, they can use deadly force?
The determination is based on, they have to have probable cause to believe that their life or the life of another is threatened with death or serious bodily harm. So if they reasonably perceive that threat, then yes, they can respond with deadly force.
Okay, you inserted a word there that I did not have previously inserted. That interpretation must be reasonable, correct?
It's based on, an officer's decision is based on our perception of whether his perceptions were reasonable based on the totality of the circumstances, yes.
Thank you. No further questions.
Thank you, Mr. Pearson. All right, Mr. Davis, you can step down, sir.
Thank you, Your Honor.
All right, ladies and gentlemen, this would be a good time for us to break for lunch. We'll get you back in the jury room at 1:45. 1:45. Again, remember the admonitions that I've given you with respect to discussing this case among yourselves or with anyone else. All rise for the jury.